SJC-12532, Dedania Taylor Cameron v. Janelle Walcott.
Ms. Taylor Cameron, good morning. Good morning. Same routine. You can walk up to the microphone, keep your voice up, and you two will have 10 minutes.
Okay. First, I would like to present, there's two issues that I want to go over with the court. They're two separate cases. One case is 2153, which is a small claims case regarding security deposit. And my contention with this case is that due process was not given properly, and also that the ruling, the decision on the case, ignored the fact that the defendants had myself and my husband from 2010 up until about 2017 when we moved out due to the contentious relationship with these matters, had us paying, had the security deposit held in an account, never gave us any interest for not 1 year, 6 going on 7 years, never gave us information as to where the account was for not 1 year, once again, 6 or more years. This was a pattern that we noticed from, I would say, within the first year of not wanting to give information, but we ignored it. We just kept paying our rent. We left the rental owing $0. We paid everything, about 200 and something thousand dollars to these defendants. We thought we were actually dealing with people that were honest, and myself and my husband have excellent credit, still do, even with the situation. And the whole situation arrived where, in the decision that the court made, it was the decision regarding the security deposit was made not based on the law. It was made it seems, after going over what I've been through. This has been going on for about 2 to 3 years. This is a very minor, small case that should have been decided from the court very easily, and it should have been over. And it would have been over had the court made a fair decision. From the beginning of the small claims court regarding the security deposit, I got a sense that there was some bias going on, but I wasn't 100% sure then. There was another case which was surprising to me. The docket number read 2153, almost the exact same case number, which causes confusion. You would think that the court would actually have fixed this matter. I brought this up to the court. They ignored it. The 2153, which is the 2135, sorry, which is the security deposit, the defendants did actually, the court actually had the defendants give me back 1 month's rent with the fee that I paid, ignoring that this was 6 to 7 years. The defendants actually admitted that they had violated every single thing regarding the security deposit. The only thing they did do was to put it into a bank account. Never gave us interest, never let us know where it was. Anything, all the security deposit laws, they violated, and that was admitted to. Next, I will go on to case number 2153. 2153 encompasses home violations. The home violations total to be about 20 to 30 violations. In those violations, this case, 2153, has never had final judgment issued, has never been argued in the court. On the dockets read that case number 2153 was actually, that 2153 was dismissed with prejudice. Now, with prejudice, as we all know, means that I can never bring this back to court for any reason regarding those issues, those housing violations. I had the date that we had the court hearing, there was no preparation for myself to argue case number 2153 about the housing issues. because I did not have any of the documentation. I did not have anything with me on that date. There was no intention of arguing that case. That case was not going to be decided. And number one, that case did not belong in small claims court. Had the magistrate actually acted properly in following the law, he would have taken that case and put it to district court. Without him even doing that, I already had sent into the court a dismissal via fax and via certified mail, which was received to the court on 11/18. The case was not to be argued until 12/2/16 of 9 a.m. So there was no intention on arguing 2153, and there was no preparation for 2153 at all. There was no agreement between the defendants or myself. We haven't been able to agree on anything. And there was no agreements between themselves and I on any matter. Furthermore, I do not need their agreement in order to drop the case in small claims and move it to the correct venue that it should be sent to. I did secure my rights regarding that, yet the courts actually does have on the docket that they received my dismissal of 2153 without prejudice. Yet Attorney Comerford has been insistent that with prejudice has to stay on. Why? I don't know, because he knows as well as I know that with prejudice means I can never go after the defendants for these issues. So as it stands now, 2153 has not had any final decision. Attorney Comerford actually, within a letter that I never received, that Attorney Mishi actually filed recently, stated that the decision for 2153, which is regarding the housing violations, I'm sorry, I apologize to the court, regarding housing violations, that was not part of the decision. So therefore, he basically admitted, after I've had to complain to Dolly's office, the division at Quincy Court has denied me access to the files. I have had to complain to Dolly's office regarding not being able to access the files. When I did see the file, there was documents in the file that were not signed, just put in there with different dates on them, saying things that I had no knowledge of regarding the case. I just don't know what was going on, because especially since the case was never argued and no final decision has ever issued on it. And basically, this case should have been taken out of the court, small claims, as I requested, and I should have been able to actually take this case to the correct court. That I have not been able to do in about 2 to 3 years due to the fact that on the record it states dismissed with prejudice. So in actuality, what actually happened is my due process was violated. I have not been able to have my due process yet because no decision has been issued regarding housing violations till this date. And as it is, I am barred from filing anything regarding these housing violations, even though the court docket clearly shows that they did receive via certified mail and fax my documentation, which I tried to be so clear on because I myself was not comfortable with the two case numbers being so similar. So I actually, via fax, they received it on the 21st, and it was notated on the docket, and it clearly says without prejudice. So therefore, with prejudice was put on by the court. I have no explanation as to why the court did that till this day. The only thing I can make an inference to is from the beginning of the case, it seemed to me, I was just baffled at how there was this willingness to ignore the fact that this was not 1 year. 1 year would have been bad enough for these infractions, but 6 years, going on 7. And till this date, I have not been able to, I have not had any finality. I have not been able to have my due process. and have this case decided based on the law, not based on any biases or any depriving me of my due diligence. And that's where we're at. If the court has any questions, I would be happy to answer them.
All right,
Thank you.
thank you.
Okay, thank you.
Mr. Mucci, you wish to be heard?
Thank you, Your Honors. May it please the court, my name is Rich Mucci. I represent the appellee, Janelle Walcott. Your Honors, I understand I did not brief this case, so I do not have a right to argument, but I did want to appear today in case the court had any questions for me.
All right, thank you.
Thank you.
Thank you.
Thank you.
Thank you.